Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Hello, welcome to another episode of Cordell and Cordell's podcast, Life's Third Act. I am here today with Melanie McDonald. She's joining us from our Houston, Texas office. We're located here in St. Louis, Missouri, and we're going to pick up where we left off last week, talking to you about what do you need to do when somebody passes away, right? Last week we talked about what are the first things you need to be thinking about? What do we need to do immediately? We talked about securing possessions. We talked about locating paperwork. We talked about what do we pay and what don't we pay. We talked about keeping receipts, right? Melanie even gave some great pointers on things you could do before somebody passes away, right? Because when they've passed away, you've lost some authority there. Today, we're going to talk about what are we going to do with all that information, right? We collected what the property was. We collected the title. We collected the statements. What do I do with all that stuff, right? And our suggestion to you, and this may be easy to pick up since we're Cordell and Cordell, we think you should talk to an attorney, right? And I think if you listened to that previous episode, I think we gave you a bunch of reasons why that makes sense. Because the thing about the law is it's not what you know that gets you. It's what you never knew that gets you, right? Like we talked about the will, and we make assumptions that seem like they would be clear assumptions in the regular part of our life. But when we're talking about the law, it's not always intuitive, right? Sometimes rules are made for reasons you wouldn't even think of, right? We want that will to not hold up a probate estate for forever, so we make it so it's void after a certain period of time. You wouldn't have thought of that. So that's reason number one to go to the attorney, ask the questions, right? And so our first question, okay, and if you did follow last week, we talked about all that property and putting it into different buckets, things that's titled in the decedent's name, things that's titled jointly with another person, things that's titled in a trust or a different entity. Melanie, how do we know if we're going to have to go to court or not?
Well, of course, the only way you're going to find out if court is necessary is if you talk to an attorney, right? Because what we're going to do is that we're going to take that wonderful estate planning binder that you got when you met with the Cordell and Cordell estate planning attorneys, or we're going to take the shoebox that you bring in, and we're going to go through that and look and help determine what is the status of those assets. By looking at that, we can determine whether or not there is going to be the necessity for court action, or is this something that does not necessarily require court action? There are many times when people have assets, but the assets don't necessarily require us to go to court for a full probate administration. And we have some other, I guess I would call lesser intrusive processes that would help in making the transfers of those assets to the intended beneficiaries. But you have to talk to an attorney first so that we can kind of help you figure that out.
So wait, there's probate, but there's also different types of probate?
Yeah, in Texas, there are different types of probate. For example, you could have regular full-on administration probate where you have a full-on administration. You have what's called probate with a muniment of title, which is a different type of probate proceeding. You have small estate affidavits. And then sometimes, depending on whether or not you had a really, really good attorney, you could have someone who has done a complete probate avoidance structure where you either have a trust or you have assets being transferred without the necessity of having a probate action.
Okay. That is a great reason to talk to an attorney because that could be so different for every single person, right? You're going to look at that title, but then knowing exactly what needs to be done next and knowing that you may think, I know we need to go to probate, but you don't know what the different avenue is in probate. So we got that. We know we're doing something that people come and talk to me about regularly and are scared of is taxes, right? Mm-hmm. And they're thinking, okay, I don't even want to touch this money. I'm going to get taxed on it, right? Mm-hmm. Mm-hmm. What are the taxes that are involved when somebody passes away?
And just to be clear, I am not giving anyone tax advice, regardless of my extensive tax background.
Yeah, and to back that up,
how long I've done taxes.
We're going to tell you to go talk to an accountant next, right?
I'm going to tell you to go talk to an accountant.
Right.
But there are certain taxes that if, again, we're looking at the preservation of the estate, Those are the only taxes that I would be concerned about, but keeping in mind that the only one that would come to mind is if property taxes were due. But there is a way for you to notify taxing authorities for real estate, for real property, for whatever your appraisal district or your tax assessor collector, where you can notify them that that person has passed away. That way, they're on notice that it's going to be a minute before you get to collect the taxes on this particular piece of property, but it helps you avoid a different type of problem, which is moving into a tax delinquent status, which could lead to tax foreclosure. Remember that in Texas, you have 4 years before you ever have to do anything with your estate. And if you're waiting 4 years and you haven't paid taxes for 4 years, that can become a real problem. Hopefully other states, you're able to move a lot faster, but that would be the only tax that I'm considering in terms of the one that I would be most concerned about. From an income tax perspective, you have a little bit of time before you have to file that final tax return for that person. And that's going to be a different situation. But again, what I'm going to tell you when you come in my office is that you need to immediately contact your CPA. And hopefully they've taken some of the tips we gave in the last episode where that person has kept up with tax returns for prior years and they're in their binder or somewhere that's accessible to the individual who's going to take charge. If none of that's happened, then of course you're scouring, looking for a tax return, looking for a business card for the CPA so that you can go and have a conversation with them that this person has passed away. And now that they've passed away, here is their tax return. What do I do so that they can give you appropriate tax advice?
Yeah, the due diligence there on the property taxes is a good point because in Missouri, while we don't have the 4 years, it's usually a 1 year on the estate. Sometimes people don't do anything with property. And what you don't know is whether or not that property tax has been paid in the last couple years. And in Missouri, if 3 years have gone by without paying the property tax, the county can come in and sell the house to pay delinquent taxes. And if somebody was sick, and this is where I see it come up most often, right? These are these things that get overlooked in the blur of sickness where you moved her to a nursing home or something's happened. You're not paying as much attention to those things because they're not front of mind. That 3 years can come up a lot quicker than you ever anticipated. But what about death taxes? Isn't there a tax at death?
Well, there is a tax at death for very, very rich people.
Oh, well, I'm okay with that.
Right, for very, very rich people. But for example, at the state level, and when we're talking about the different jurisdictions, in Texas, we do not have an estate tax at the state level. And recently, we actually had a constitutional amendment where we won't have one at the state
yeehaw!
level.
That's great. Right? Never now and never will we have a tax.
Right now and never. So really, what you're looking at is that if in fact you have a extremely wealthy person who has taxes that would be due above what the estate tax exemption is, that's the only time that would be concerning. So for the regular everyday person, you're not really concerned about the death tax or the estate tax at a federal level. And if you are someone who is qualified for that, or the person who has passed away is in that number, they've already done planning. There's no way that you're sitting on $15 million of assets and you haven't planned, right? You haven't taken effective measures. You didn't wait till you die to tell anybody that you had that much money. So, the idea that the everyday person, chances are they're not going to have to worry about estate taxes at a state or federal level, at least not in Texas. It is important to talk to your attorney and the accountant with respect to at a state level in the various jurisdictions, because there are states that do have state level estate tax. And so we call it death tax, but that's basically what it is the estate tax.
Yeah, I called it death tax because that's what they ask when they come in. But right. Illinois is one of those states. I practice in Missouri and Illinois. You said that federal exemption amount is at $15 million today, right? It changes. It's changed by the Congress and the president, and then it's usually set to inflation to raise over the time. It's $15 million right now because of that big, beautiful bill. But in Illinois, they have a $4 million exemption, right? And the thing, and again, not tax advice, we're just trying to describe to you how some of these things work. If you are over $15 million on the federal level, you only pay a tax on the money over 15 million, right? Whereas in Illinois, once you hit that 4 million, everything gets taxed all the way down to the first dollar. So it's definitely something you want to be thinking about, right? And Melanie, I think that she's a good planner and assumes that people are thinking of these things. Sometimes they're not, right? And sometimes, you're not wealthy all of your life. Say you built a business and, you've been scraping by forever, and then somebody comes along and buys it for, 10, $20 million. Now, all of a sudden, you've got this, and that may not have been something on your radar, right? And so, but my clients in Illinois, that really hits people, farmers, right?
Yeah.
And you wouldn't think about this because farmers are scraping by right now. It's really difficult to make it a profitable enterprise, but they've got a lot of assets, right? They got the land, they got all this heavy duty machinery that's hundreds of thousands of dollars. Getting to that $4 million happens pretty quick. And while it's not something that's liquid, it's definitely something they should think about, and they should talk to us in their planning, and then we will bring in the accountant to make sure that any plan is being followed. So we're talking about property. How do we know? Do we need to get it all appraised?
I think that that's really going to depend on what your situation is and how those assets are being transferred. Typically, if someone passes away, their assets are going to take whatever that date of death value is. If you are in a taxable situation, yeah, you're going to need to have some type of formal appraisal done to determine what that is. Like I try to tell all my, my billionaire friends when we're having, sitting around the table having glasses of wine and chit-chatting over coffee, that maybe, that this is something that they should consider with their growing businesses, because you're right. When you have a business that it may be $1 million today, but just one transaction away from being in the category of having to worry about that. It's just one of those things where now that you're there, what do you do? Like, how is it that you're going to make the plan on dealing with that? Now, in one of the things that I like to think about is that you have the value of that asset. Well, the person who would have best known what that value was is gone again, right?
Right.
That person's deceased. So how are you going to make that determination? So if it's a house, of course, you can look at the county appraisal district, but is that an appropriate value in terms of what that asset is? If you have an office building that is, 15 million or more, that's an asset that you would likely have to have appraised in order for you to assess that value. I can't go and say, oh, well, it's big. It looks
big.
like 20 million to me. And so just the ordinary everyday person is not going to be able to assess the value of those assets. So when you talk about farming, small businesses, and people don't realize, especially when they've purchased their real estate, depending on where it is, and they're operating their business from that real estate, they're not going to really have a good idea. They're immediately going to think, well, I'll just look at my tax statement because it says fair market value on my tax statement. But there is a very big difference in what the tax assessor collector determines as fair market value and what is actual fair market value. And that's where your appraisal comes in.
Yeah. That I always want my assessment to be low because that's what my taxes are based upon.
Exactly.
But then I don't want to sell it for that price, right? So
that's right.
I get what you're saying there. All right. So we're talking about taxes. We're talking about who we're going to talk to next. This is where we're going to bring in the accountant, right? Because our expertise is only going to go so far. We're going to work with other partners. And what she was just talking about, I think, is a good reason for why you want to assess your plan regularly, right? Every year when you're doing your taxes, you're looking at everything and thinking about it, but maybe you're reaching back out to us every 3 to 5 years because of things that can change, right? You sold that business, and one of the things that people will ask me about related to estate taxes, they're growing is what can I do if with all my billionaire friends, right? Melanie, I have some of the same friends, and what I will say to them is time is your best friend. Because the more time you have to move property out of your estate, the better chance you're going to have at reducing that and not hitting that tax. And so that's just a little plug to all of, the Stephen Colbert used to do that billionaire minute. All right, all my billionaire friends, look at me right now. Talk to your accountant, talk to your attorney, because you need to do planning sooner rather than later. All right, so we go to talk to the accountant, I say. How do we know? Who are we talking to? How do we know who the accountant was, or even if they had one?
Oftentimes there isn't one, especially if it is a regular everyday person, because most of the people that we're going to deal with are regular people just like us, right?
Right.
Small business owners, however, are going to be, you're going to look at who it is that's operating their business. And sure, for a while, you may be the person running your business and you're keeping your own books. But most business owners learn very, very quickly about trying to operate the front office and the back office at the same time, and the ineffectiveness of being able to continue to actually do what it is that you're in business for, and the administration of all of the finances and the paperwork and all that type of stuff. So what you're going to hope is that there is a bookkeeper. So how do I find that person or that CPA? And literally, we're back on the treasure hunt, because what we're looking for in the documents that are in that shoebox or that are in that wonderful binder, because we have such wonderful people who have come to Cordell for their estate planning, and they're going to open that binder and there's going to be a business card for that person. If it's not, we're looking through the wallet, we're looking, in between the mattress. We're doing the same thing we did when we were trying to procure all the other documents, to make sure that we can find a paper trail somehow on who that accountant is. If there isn't one, which would be shocking for someone who is running a small business that is successful, right?
Okay.
But if that is a person, they were just starting out, they were just getting things started, and maybe they hadn't hired one yet and they had the ability to maintain it for themselves, I can check their computer. I want to see whether or not they've been using QuickBooks. Is that a program that's on their computer? There are all types of accounting programs that they may have. If I have access to this, and this is something else that I often tell my clients to do, you need to have a password bank for those things. Because if I need to get into your QuickBooks, I have the password, I can look and see whether or not you've linked an accountant in that program. Because as a QuickBooks accountant, I can actually go in and connect to my client's account. All of my information is there. So when you're looking at trying to figure out who I am, and you want to, well, dad's gone now, but his business, he did everything himself, but we don't know who his accountant is. That's one place that you can look, but you have to have access. So it's definitely one of the things where more preparation is better, more information is better. And so that type of information becomes critical, so that you're looking in the places where he did business. And also, like, even when in the operation, say it's a clothing store or a mom and pop shop where they sell different tchotchkes and trinkets and things of that nature. In the access in that business, somewhere there has to be in the business records an invoice from someone who provided a service.
Yeah.
And so that's what you're looking for. We're looking at the credit card statements, but we're not opening the ones that have the credit cards in them. But we're looking at the statements, and maybe even the ones that are already open, but we're looking at those things to see who are you paying. Because if you're paying an attorney and you're paying an accountant, or there is a service listed in that account, I can then go and contact that person and kind of determine what was the status of your accounts for that business.
Yeah, and you brought up a great point about the password manager, and it's something that I tell every client at the end of our signing and the funding, and we're talking about next steps. And this is so much more prevalent now than it was even 10 years ago.
Absolutely.
And it's because of something that's changed, and it's called two-factor authentication, right? And it may be the bane of your existence that you, every time you go, what is my password? Oh no, I can't remember. Or you go into something you go in regularly and it's like, we're going to text you. Okay.
Right.
Now, do me a favor, put a feather in that thought, because the people that are going to be managing your estate, and I'm always thinking about that gap again, right? Between the time that somebody passes and the time they have actual authority to act. They're going to need to pay bills, right? And a lot of that stuff is hidden in that computer, okay? So first off, if you've got it password protected, write that password somewhere and let somebody know where it is. Second, your phone is the best amount of information we could ever ask for, because it's got your email in it, it's got your phone numbers, but every time there's a two-factor authentication, if I can get into your phone, I can deal with it because it'll text,
Right.
it'll email, all that stuff should be on your phone, right? And so I tell people, if you do one thing right, it's let people know how to get in your phone, right? And if you keep the passwords, I'm not trying to call anybody out here, right? But if your passwords are in the notes of your phone, right?
Right.
Let people know that they're in there. It's really helpful. I for one, I use a password manager, mostly because I'm lazy, right? And I don't want to have to remember all this stuff. And they make me change. It happened a few years ago where I was like, I got to change this. I can't remember what the last password is. I got to make up a new one. I'm not that creative, right? I don't need to know how to make a new password. And so I have one password. I put it in there. Everything's kept in there. It's been amazing. If you have that, though, you got to let people know what that one password is, right?
Because they have to have that one password to get to the other passwords.
Or like when people, I give them that binder at the end of the meeting and they go, okay, great. I'm going to go put this in the safe at home. And I go, stop. Who can get in that safe, right?
Right.
Because it's good at its job, right? Which is keeping people out. And I want you to protect these, but I also make sure that somebody's got that key or that password. And by God, don't put that key in the binder and then put that in the safe, okay?
Right. So here's a tip that something that me and my sister have done. And I know this may sound, I don't know, crazy, but in my phone is not only my fingerprint, but is also my daughter's fingerprint and my sister's fingerprint. So if they can get into my phone, my fingerprint is going to unlock every single app on my phone with my fingerprint.
You can add
If I
extra
have
fingerprints?
I'm sorry?
You can add extra fingerprints in the security?
Yes.
I did not know that.
Yeah, I have my sister. Guess literally, if I go to my sister's house and I need to get anything, if she's, something happens to her, I can put my fingerprint on her phone. It will open. I'll have access to anything. Now, of course, you're going to make sure you put the fingerprints of somebody.
Trust that person. Yeah.
Right. But, of course, my sisters take care of everything should something happen to me. But my youngest sister, her fingerprint is in my phone. And I have an entire profile in my phone for her. She has access to all of my passwords. She can access all of my social media. She can access all of my accounts.
That's great. That's a great tip. I didn't even know that. But there is one other thing before we move on this one related to phones. There is legacy options in a lot of phones.
Yes.
Apple has one. Google has one for a lot of Android. I think Samsung might even have one. The thing I want you to be aware of with the legacy is it's not access to the phone. It's information stored in the phone, right? So you may name somebody and you thought, oh, I gave my spouse the ability to access my phone because they're named in my legacy. All they're going to get is access to the files that were on that phone. And nobody, even the government, has been able to get into Apple phones.
Absolutely not. No matter what the subpoena is, I've not seen one
that
can crack that.
So this is real important, making sure you have a plan for somebody to get in your phone. And that thumbprint is really good idea. Okay, so we've talked about the accountant. What needs to be filed? Well, first off, with the accountant, can I get... They're not a small business owner. They're just a regular person, right? Just a W-2 person, as I would call them. Can H&R Block handle this?
Well, I think that H&R Block can handle it, but the question is really going to become, to what extent do you have access to the documents to give to H&R Block, right?
Okay.
Because before you can get to them, and a lot of times it's really going to depend on whether or not the person that you're assigned to an H&R Block has the experience or they have the certification to do that type of final tax return for the decedent. And a lot of times they do, sometimes they do not. And it's just really going to depend on that individual. Personally, I'm not saying not to partner with H&R Block, but sometimes depending on the status of the assets and the sensitivity of what's going on, you may want to have a private person, an individual that you're able to rely on in terms of managing that final tax return for the decedent.
Yeah, and somebody you can come back to regularly. I don't know enough to know if you can have somebody you're working with for a year or two at an H&R Block as opposed to somebody in private. But, it's hard to find an accountant nowadays. So you made a distinction there, though. I was thinking about filing that person's last tax return, right? Because, but there could also be separate tax returns other than that?
Well, it depends, again, on what we're talking about in terms of the individual. What are the size of the gifts that they have made? If they're a person, like I said, in my billionaire class of friends, if they've made gifts, there could be the potential for gift tax returns. And so there are also, different types of taxes that the government may look at you for. And the gift tax return is not specific to whether or not a person has, has died, right? And so that's a consideration that has to be made even in the process of a person living. That's why I feel like, okay, if you've done that and you have that much money,
Right.
you have a professional. There's no way, because the IRS is going to let you know. I mean, you move $15 million if you want.
So my takeaway here is H&R might be able to help. TurboTax is not going to do the job. I need to get some help here. I need to go talk to somebody.
Yeah, and I think that's the idea, is that you're going to need a person, not necessarily the software platform. So when you said H&R Block, I'm thinking of the storefront where there is a person.
Me too. Yeah.
But if you're talking about the software, which is a TurboTax or an H&R Block software where I sit down and follow a script, I don't think that that's going to cut it. I think that you're going to need more assistance than that.
Yeah, there's too many options here, right? It's just like going to the probate court. I might know I need to get to the court. I don't know which option to choose.
I don't know which one to pick.
Right,
Yeah.
right. Okay. So we've talked about an attorney, right? We've talked about an accountant. Now let's talk about banks, right? I've got the death certificate in hand. Who do I notify?
Well, you're going to notify everybody that needs to know.
Okay.
So how do we determine who needs to know?
Right.
One of the things that's really important is that with death certificate in hand, I'm not so sure that I'm running down to the bank immediately to notify them.
Why not?
Why? Because if there is anything that is on an automatic payment, that payment could potentially be stopped. And if you are in the process of engaging in a probate, where you have to go to probate court for anything, if that process takes 30 days or 60 days, then you have a situation where the bank has now put a hold on the funds and they've stopped those automatic payments, right? So the idea is that you have to kind of be strategic in how you notify. I'm definitely notifying credit card companies to the extent that I do not want, if I don't know where the card is and all I have is a statement, then I want to notify the credit card companies because I don't want any unauthorized charges after that person has passed away.
Right.
The challenge there is determining whether a lot of folks, they put their bills on a credit card and they pay them off at the end of the month so that they can get the airline points.
Yeah.
So are you cutting off your nose to spite your face?
Oh, is that where the automatic payments are coming from?
Right.
Oh, wow.
And if the automatic payment is on the credit card, then you've just blocked that particular transaction from happening and now the lights are off.
Yeah.
And so unless you have the authorization to reinstate those services, you've got a problem. So you just have to be very strategic and how it is you move through that. Sometimes even, here in Texas, depending on the circumstance, we do have the ability to do emergency allowances or even emergency administrations. So if there's a business that's being operated or something like that, and you're going to need access to those accounts, there is the ability of the court to put someone in place immediately to manage that. And that way you have the authorization. It doesn't mean that you don't have to go through the full process. They still just have the ability to look over your shoulder. The way around that, of course, is where you have your business interest in a trust and you have a succession plan on how that business is going to be run after your passing. So those are other things that are considerations for the small business owner. But for the regular everyday person, I'm not sure I'm taking the death certificate and passing it out to everybody who can, shut down everything immediately without at least making sure at first I have the ability to administer what I need to protect that estate.
And that's another one that I see as counterintuitive. And people do this all the time. And I think it's because it's one of the things they feel like they can control, right? And you're trying to knock things out. You're like, oh, I got to let everybody know, right? Yeah. And you're not thinking about automatic payments. And you're not thinking about the fact that the moment they freeze that bank account, you're stuck, right? Because you can't do anything with it. That's some really good advice. So pause and maybe talk to the attorney before you start determining that and let them help you pick those things that you want to notify at that time. Okay.
Absolutely. I think one other thing, just another little carrot to throw in there when we look back at planning, when we're talking about the individual who is making preparation for this moment, that there is the ability also determining how that account is titled. You might have a specific account that is for the purposes of paying bills only, right?
Mm-hmm.
And that particular account has a payable on death, or it has a person who is a joint holder who you trust, who you know is going to take care of those bills. And so they
Right.
don't have that problem. And then the assets that you want to distribute, you just simply have that in a different account. And that's going to be handled by your trust or your will or whatever instrument you use to distribute that property.
That's smart planning. And I think and I'll give a plug to the trust here, because one of the great things about that small business we were just talking about is it doesn't die when the person dies, right?
Right.
The entity still exists. It's just that the person that owned it passed, but the entity, and this causes problems in probate estates sometimes, because small business owners out there, think about authorized people on your checking accounts. Okay. This is one of the biggest issues that comes up. Is that, but you get a little taste of that by having a trust, because when the decedent, when the person passes away, their trust is still alive, right?
Right.
And why there's things that change within the trust. The next trustee steps up and it continues in administration. You don't have that gap. And I think that's maybe one of the biggest beneficial things I've seen to the people you leave behind, is they have that ability, that what's in that checking account, you can go ahead and notify them, because all they're going to do is change the trustee.
Change the name.
Right? Yeah. And so that's a good little tip related to having a trust. So, all right. So we talked to the attorney. We've talked to the accountant. We've notified the appropriate people to notify. What's the attorney going to tell us to do? Administer the estate, right? And there's a lot of different ways this can go, from going into probate, going into a trust administration. What do I do with the money, right? So we've got this checking account. If it's closed, how do I access it once I have been named by the court, let's say?
So in Texas, you actually cannot use the decedent's account anymore. So that account has been blocked now, and they're going to basically either give you a transfer or they're going to give you a check. And if that check's going to say to the estate of whatever that person's name is, well, you can't really do anything with that check unless you have a bank account that says to the estate of.
Okay.
And you have to also get a tax ID for that account. So say, for example, we're going through the probate process, and this is presuming that you have probated a will or you have established a determination of heirship, and now there is an open administration, an independent administration, or a dependent administration, which, of course, the different probate types, you let the attorney figure that out. But once you have an administration in play, you're going to get a tax ID number from the IRS, and that is what you're going to use to open that bank account. Well, that bank account has to match the name of what you got that tax ID for, which can only be the estate of their name, which is exactly the same as where you probated it. If you're using a trust, that account already exists, right?
Mm-hmm.
Likely you have already done the portion where the estate account already exists. The tax ID number, if you're using the tax ID number, if the decedent passes away, you're not using their social security number anymore, but you're going to get that tax ID number for the trust. You should have that already. And so that's really what you're looking at. So that's going to be where you establish the account that is going to manage or take care of the estate.
Okay. And this is a phone call I get a lot, because sometimes people don't call the attorney till they get stuck. Right? they try to
down at the bank.
That's exactly right. And the phone call I get is this. Yes, Mr. Sauter, this person, this bank teller, is telling me I need letters.
Right.
What are letters?
What are letters?
What are letters?
So letters are, it's authorization from the court that you're the person in charge, right?
Okay.
This is post probate proceeding. And there's a couple of ways that we get letters here in Texas. You either have letters of administration or you have letters testamentary.
Mm-hmm.
If you have a will, you're going to end up with letters testamentary, and that's that one person who is in charge to take care of everything. If you didn't have a will, or you're beyond that 4-year period, or in your state, 1 year.
Right.
But in Texas, even beyond the 4 years, you still have the ability. The will is not necessarily void. It just takes on a new life. Because now what we've done is we've annexed that will to our administrative process, right? So what we do is now we have letters that say we can act. So depending on what your probate circumstance is, you're going to need those letters. Those letters basically say, this is the person that the court has established is responsible for taking care of all the matters of this estate.
Okay, so the attorney can't give me letters. It's got to be a
Nope.
judge.
It's got to be a judge.
Okay, so now we're actually starting to move through the probate estate. What do I pay? I mean, what do I've opened this bank account. I've dumped the money into it. How do I go forward?
So here in Texas, of course, my advice always to clients, you're going to stay in constant contact with your attorney. If you ever have a question, whoever probated your estate, that person should also be someone who is skilled in knowing how to manage the administration of the estate, right? So when you are looking at what do I pay first, it is only going to be those things that preserve the protection of the assets in the estate. And that's particularly if you're not the sole beneficiary of the estate. If you have to answer to other people for the money that you're paying out, you're not paying out things frivolously. You're not paying credit card debts. You're not paying any type of debt that, credit card or anything like that. You're making sure that only the things that are necessary to preserve the assets in the estate. So, of course, if there's a car note, you're going to pay that.
Yeah.
If there is a house note, you're going to pay that. You're paying the insurance, you're paying those things. So when you think about what are the assets that need to be moved from one party to the next based on this particular instrument that we're looking at,
Right.
and that's whether you're doing trust administration or you're doing probate administration, you're looking at your governing document and saying, okay, who is it that's going to get this? And do I need to preserve this asset for them? So those are the things that you're paying. Every other debt in the state of Texas, they have to file a claim. And when I talk about unsecured debt, all of those folks have to, you publish a notice, they get to come down and file, their claim with the court or with the executor or administrator of that estate and say, this is what our claim is. But you don't have to pay that right away. You're going to work with your attorney to make a determination of, number one, is it valid? Are we able to trace the source of their debt? What is included in that debt? Do they have the actual documentation to support that debt? And is it actually valid? And so in working with your attorney through that process, you make a determination on what gets paid. So only that which preserves the assets that are in the estate that need to be distributed to someone else.
So only stuff that's necessary up front. And then, so in Missouri, that period, that creditor period is 6 months. Okay.
Wow.
And so we advise our personal representative, executor, whatever it's called in your state, don't pay anything until we get to the end of that 6 month period, because there's two things going on here. First, is that a valid debt? Okay.
Right.
The court's the only one that can say that unless you agree with that, and you're going to want to do that with the consent of everybody involved. That who's that money that you're holding, right? Because you're just administering it. You are now the fiduciary. You're holding this money for the benefit of these other folks,
others.
right? But second off, there's an order of what's most important, right? And so let's say you pay something that you thought was valid, but there's a bigger bill that was higher on that class rank, right? So that's why we wait on paying stuff even till the end of that 6 months, just to make sure that everything that needed to be paid was taken care of there. Right.
We have a similar structure, of course, here in Texas, where we have the priority of the claim. But when I'm talking about specific things, we're talking about mortgage, we're talking about insurance, we're talking about making sure that utilities are paid just to preserve that asset. Because if you have insurance that goes unpaid during that 6 month period, you now have left vulnerable an asset that doesn't belong to you. And if someone sets fire to that house, you've got a problem. Because now have you breached your fiduciary duty by not protecting that asset? So it's definitely a situation where you're talking to the lawyer to determine what should I pay and what should I not pay, and what am I going to be covered for if I do have to pay something.
So speaking of who gets paid, there's something that comes up pretty regularly. I've got the will that says everything's going to go to me and my siblings. Well, one sibling, and she's been kind, she waited about a week until after the person passed away, but she's got a child that's about to get married, right? And they need this money now, okay? Mama's gone. Why can't I have it, right? And the attorneys told me we got to wait 6 months before we're paying any debts. Does that count for distributions too?
Well, I think that what you have to look at in terms of when a distribution is required to be paid in whatever the underlying instrument is,
Mhm.
right? And I think that that's going to be the important thing to consider. So just because someone shows up and says, "Hey, it's mine, I'm supposed to have it, give it to me," you don't really have that opportunity because in the situation where you have the administration of an estate that has gone either through an independent or dependent administration, you literally have to make sure that the inventory of all of those assets has been determined first and approved by the court. So you can't just go willy-nilly and just make a distribution when you haven't done the steps that are required to verify what the assets are. Because in a situation where a creditor is entitled to payment, if you pay out to a beneficiary, right, monies that should be allocated towards a creditor, in any circumstance, that creditor now has the ability to file a claim against that particular fiduciary. So you don't want a situation where you're, paying out monies to folks and there are claims pending,
Yeah.
right?
Yeah.
After you get past the claim deadline for when, if you didn't get your claim in, and I can't remember right offhand what the deadline is for when the claims have to be in, but there is a deadline on when the claims have to be in. Once the deadline has passed, then you're looking for to make sure that you've had approval of that inventory by the court, and then you can move forward to the distribution. But you have to make sure that valid claims are considered. The determination of a valid claim I feel like that's where the soft area is. How do we determine what is a valid claim? So that becomes something that you work with your attorney, and why we need all those statements and why we need to be looking at all those documents to figure out what is actually a valid claim.
Yeah, the more information, the better. And you said something there I want to hone in on, which is the fiduciary, that personal representative or executor. When a lot of times people want to be in charge, right? Especially with your family. I go back to that oldest child. They always, they're in, mom and dad's gone. That power vacuum is there. They want to fill it, right?
Right.
Not so quick, okay? Because
Right.
you love being in charge, but do you love being responsible and accountable, right?
Right.
Because that's what's really going on here. And when I'm telling people, they're naming people in these documents, I'm telling them, you're not bestowing a gift here, you're bestowing a responsibility, right?
Correct.
And when you made that early distribution, right, because your sister was very persuasive and you love your niece, right? You want her to be able to have her wedding, and here it comes up all the time. That's what mama would have wanted, right?
Right.
And I agree with you that that's what mama would have wanted. But they're going to get the money. They're going to go have the wedding. If that money should have been to a creditor, guess who's in trouble? Not the niece, not the sibling, the
That's right.
person that made that soft decision to give them the money when they shouldn't have, right?
That's right.
And so this is really one where you've got to be thinking that they're wanting something from you, but they're not protecting you. You've got to protect yourself in these situations.
That's right.
And your attorney should be on that. So we talked about when distributions would be made. I'm going to cover one last thing here, because it dovetails from what we were just talking about protecting yourself. How do we protect that fiduciary, right? What are some steps that they can do? We've already talked about making sure you talk to the attorney and follow them, but they're going to make these distributions. Is there, at the end of the administration, is there any chance that some of this stuff can come back on them? Is there a way to close the door on the administration at the end so they know they're done?
Well, in Texas, we do have the ability to administratively close an estate, and that's going to be because there is an independent process for the administration of the estate. Literally, when you pay those debts, people are able to go in and say, all right, we've paid all the bills, we've filed our inventory, all the bills have been paid, we're done. And that case will be administratively closed, and that person can be relieved of that duty, right? And if a creditor feels like, wait a minute, I was left out of this, they have the ability to approach the court and present to the court, well, this is what it is that I believe I was due that I didn't get. So the protection for that person who acted in that fiduciary capacity, where are your records? Because just because that individual went and filed a claim and says, hey, you forgot about me, you're going to look at what were the deadlines? Did they meet the deadlines? Did they meet the prescribed format in terms of what a claim should have been submitted in the proper format? Was it a sworn account? How did they submit that claim?
Right.
Because just because they come later and say, hey, wait, what about me? still doesn't mean that that is a valid claim.
Right.
So you still have to make that determination. But the only way you can trace your steps is I have the records to show this is what I did. I had approval from the court. This is who actually made a claim. This is who we negotiated with in order to dispose of that claim. And once that was done, this is the distribution that I made. So a come lately debtor is probably in a situation where they've got more of the burden to prove that you ignored them rather than you nefariously paid out something that they were due.
Okay. And one more thing I want to touch on here, what we've been talking about in administering and distributing, we're using probate as the background for what's organizing all of this. If you are in a trust administration, I would say you don't have the benefit of these rules. And I say it that way because I've seen, I think trusts are amazing and they can be used really well, but like anything else that they can be misused, right? And I think people get too lackadaisical with their administration in trusts. You got to make sure that you're tracking everything. And this is where I would lean on the attorney. Even if you have a trust, even if everything's titled to the trust or to go to other people, still go see that attorney, because there's certain notices that are required in the trust that you're going to have to give to the beneficiaries. And something as far as closing it out, right? You're going to want to do that accounting. I know nobody wants to, right? And I get this pushback all the time. Me and my brothers and sisters, we get along fine, right? Nobody's going to come after me, right?
Okay.
And maybe it's because I'm an attorney and I only see the worst, right? Because they come back to me when the problems occur. But I think it's worth the extra effort and maybe time and maybe even money of making sure that all that accounting's put together before you distribute, right? They've looked at it. They've seen everything you've done, and you can do something called a receipt or a release, right? And they might not have to sign the release, and you'll talk to your attorney about what all can be in there. But you want to make it so that you've done all this work. You don't want to get punished for it, right?
Right.
You're going to distribute it, and that person's going to receive the check, but they're also going to sign off and say, he was clear with me about everything he did. He didn't do anything. He's not manipulating me. He's not making me sign this to get my money. I will, if you can get this far, indemnify him if something were to come back, and then everybody's got a stake, right? But you're only going to know those things if you talk to an attorney. And they're not intuitive, and they might be written in that 70-page trust, but I can't tell you what page that might be on. So come talk to me. We're at the end of our second session here on what to do when somebody dies. I want to thank Melanie for spending her time with us today. She gave us some great advice. She gave us some great perspective for us folks in Missouri. And that's just 2 states, right? Missouri and Texas. I'm telling you, folks, it varies all over the place, right? You can't do this on your own. You need help to understand what happens in your locality. So reach out to us. We're in now 16 different cities where we're helping people with these problems. Thank you, Melanie. And we look forward to seeing you next time. Like I said before, if you have any questions about what we just talked about, please drop it in the comments. We'll take a look at them, and even new ideas, things that we didn't talk about. Hey, I'd really like it if you guys discuss this. Let us know so we can make sure that what we're producing is what you want. All right? Thanks for joining us, and we'll see you next time.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.